Now, in this video, I'm going to show everyone what music placements really are. Because, in fact, a lot of people don't really know what a music placement is. So in this video, I'm going to show everyone exactly what a placement in music really is. Check it out. Now, according to Iree's take, music placement, often referred to as sync licensing, is the process of getting your music featured in visual media like TV shows, films, commercials, and even video games. Artists earn money through upfront sync fees and back-end performance royalties when their tracks are successfully placed by music supervisors. Now, why music placement matters? Now, lucrative payouts. Sync fees can range from a few $100s to local TV to tens of thousands for major commercial campaigns and blockbuster films. Royalties. Every time the project airs on television or streaming, you collect back-end performance royalties through PROs like ASCAP, BMI, or CSAC. Massive exposure. A single sync placement in a hit show or video game can result in an exponential spike in your streaming numbers and fan base. Yeah. Now, how to get your music placed? This is the catch right here. To secure placements, your music needs to be easily accessible, perfectly formatted, and cleared of any copyright issues. I say again, clear of any copyright issues. So what does that mean? Number one, you have to have your music readily available, and it has to be perfectly formatted, right? The standard 44.1 kilohertz, right? Sample rates, and cleared of any copyright issues. So basically, your music has to be original. If you have music with samples, right, the samples must be cleared before it can be considered a placement, right? Clear your rights. You must have 100% ownership or control of both the master recording, the actual audio file, and the publishing composition, the lyrics, and the melody. Now, what does that mean? If you have a song with lyrics, right, someone has to be credited as the songwriter, right? And that's where the publishing comes in that. And the melody, right? That's important too. Because lots of music have notes. So you notate the actual notes, right? And you're credited for the creation of that composition. That's also where publishing works as well. Now, submit to music libraries. Now, this is key. Work with pitching companies or music libraries that actively represent artists to supervisors. Yeah, a direct connection from an artist to a supervisor. Some like Music Gorilla or platforms like Sync Placement act as a direct database for these opportunities. So there you have it, folks. You have an example right there. Music Gorilla and Sync Placement. Have your songs and have your ideas professionally mixed and mastered and ready to go, right? And then you have the platforms right here where your libraries can be submitted to. Understand library types. You can pitch to exclusive libraries, which secure rights for specific songs and take a larger cut but push harder for you. Or non-exclusive libraries where you can pitch the same song to multiple catalogs. So you have exclusive rights, then you have non-exclusive rights. That's important too, right? We're going to dig deep in both non-exclusive and exclusive rights. Now, non-exclusive rights grant a licensee permission to use intellectual property such as a photos, software, patents, and of course, in this case, music, while the creator retains ownership and can license the same property to multiple other parties. Now, you see these non-exclusive rights when it comes to beats. You see these beat makers out there, many of them on beat making sites such as BeatStars, right? And they sell beats. Well, they sell non-exclusive beats. That means not only one person can get that on that beat or use that material, but multiple people can use that material. This allows widespread use. It's common for stock images or software and often results in lower fees for users compared to exclusive licenses. Now, when music is concerned, now that's not always the best thing to do. Because if you have a non-exclusive right to a song, even though you spent a small fee to acquire that non-exclusive right, so could everybody else. You can have 100 people playing the same beat, and the only difference is just your lyrics. Do you understand? Is there something wrong with that? Well, it would be kind of odd hearing a song with the same instrumental, but with a different title and different lyrics. That's will be a very odd situation. But that's how non-exclusive rights work, right? Anybody can use that gear as long as they pay the fee. You can use it, and you can make some money off of it. But if still, the person who owns the property, who owns the beat, who initiated a non-exclusive right, can also acquire some monetary compensation as well. So be careful with that. Key aspects of non-exclusive rights include multiple users, as I said. The licensor can grant similar rights to competitors or various third parties simultaneously. Owner retains rights. The original creator or owner can still use the work themselves. Lower costs. Because the user does not have sole rights, these licenses are generally less expensive. Common applications. Often used in stock photography, software licensing, and content licensing for broader distribution. Now you heard it right there. Some of the examples: photography, software licensing, and content licensing. Nowhere did it say beats. Nowhere did it say beats. Now, why is that? Why didn't they use beats or music as an example? Because you see a lot of these beat makers promoting their tracks for non-exclusive rights, right? Where anybody can use that track and put lyrics on it. I want you to think about that, right? That's why everybody sounds the same. If everybody got the same beat, everybody sounds the same, don't they? The only difference is the lyrics and the title of the songs. So, something to think about when it comes to non-exclusive rights. Now, exclusive rights or exclusivity are legal prerogatives that grant an individual or entity the sole power to perform specific actions, such as reproducing, distributing, or displaying a work, while permitting them to deny others from doing the same. Primarily applied in intellectual property, copyright, patent, and contract law. These rights are a form of monopoly that allow owners to control and monetize their assets. And now that's key, assets, right? And just like when you purchase gear, right, that is considered an asset. So when you purchase gear, right, or purchase an MPC or some type of keyboard, and you create music, you record it, you record that particular piece, right? You print that track, and that track becomes a master. That is also considered in the music space as an asset, because you can use that composition, that creation, to earn revenue. But to protect that asset for non-exclusive use, or use where individuals can steal your idea and get away with it, you use an exclusive right. Right. Basically, it's a legal prerogative that grant an individual or entity the sole power to perform specific actions. Right. But they have to pay a huge amount versus the non-exclusive amount. And as I stated before, this material must be copyrighted, have a patent, in order for the owner to properly earn money from that work or from that asset. So pay close attention to what I just stated there. Now, key aspects of exclusive rights. Definition: the legal authority to act and to authorize or prohibit others from acting regarding a specific asset, such as copyrighted work. So, people, I want all you individuals in the music production space, right? I want you to listen to me carefully. It may not be a good idea for you to be posting those beats on social media unless you have paperwork that can protect your asset. Right. I want you to listen to me closely. You see all these individuals constantly posting beats, posting songs or whatever. Right. They may have songs in their beat store, right, which they sell. They have non-exclusive rights and they have exclusive rights when they advertise those beats for sale. Now, that's highly important. And the reason why those beats are promoted on social media is because they already have the paperwork for them. Now, I know a lot of individuals, right, have been caught promoting music, putting beats on their pages, and there's no paperwork attached to it. There's no rights at all. And that's how AI companies and some people who troll these pages, right, these music pages, they can easily steal your work. They can steal your idea without you even knowing it. So that's why it's important, right, before you post any composition that you feel that you can earn a living from, make sure you have it copywritten, you have the pertinent legal information created to protect that idea. And once everything has been finalized, then you release it. Then you release it to the public, advertise it for opportunities in sync, in placing, right? But let me move on. Types of exclusive rights. The copyright. Under 17 U.S.C. 106, copyright owners have the exclusive rights to reproduce, prepare derivative works, distribute, publicly perform, and publicly display their works. Right? So basically, if you're the owner of a particular composition, right, you own the copyright. Then you own the right to do whatever you want to that asset. Do you understand? But, right, if you are a creative and you sell that copyright, right, or give an individual an exclusive right, then that individual can do whatever they choose to do with your asset. Does that make sense? Right. Contractual rights, often used in contracts to restrict parties from performing certain actions, such as working for a competitor, for a set period of time. Now, yes, there are stipulations, right, that you can legally assess when it comes to exclusive rights. There are restrictions you can add. So keep in mind, if you don't want a particular individual from using your work, you can specify that in the contract and restrict usage from those individuals, right? It can happen. You can do that. Just keep that in mind. Exceptions. Exclusive rights are not absolute. For example, the first sale doctrine allows someone who lawfully purchased a copy of a copyrighted work to sell or lend it, despite the owner's distribution rights. So you heard that, right? It's not absolute. If you own that right, you can allow someone else to purchase a copy of that work. Yes, you can allow someone else to purchase a copy of that work. But that individual had only purchased a copy. They don't have the legal right to sell it themselves for a profit. Do you understand? Now, duration. These rights often have limited durations, particularly in patent law, after which the works enter the public domain, right? We have copyrights that actually expire, right? Once they expire, then anybody can use that work without being legally held responsible. Do you understand? So if the copyright expires, everyone has the exclusive right to use that particular work and earn money from it without any legal ramifications. Do you understand? So here's some key context right here. Copyright law protects original creative work, giving creators control over how their works are used. Patent law grants investors exclusive rights to their inventions, excluding others from making, using, or selling the invention. Business contract agreements that limit, for instance, a distributor to being the sole seller of a product in a specific territory. Now, for you YouTubers out there who keep putting beats out there and putting music out there without any paperwork, I'm telling you now, I recommend, I'm giving you the information, now according to the information, right? And from what I have ascertained and delivered to you, it appears that just placing beats on YouTube, beats that you know for a fact, I'm talking about the full intro, outro, and the body, right? I do not recommend you do that. Because if you do that and there's no paperwork behind it, that means there is no copyright. The same way a copyright has expired, that means anyone can use that work. Anyone. Now, that's why it is a good practice if you want to briefly highlight a particular work, right? What you do is give a snippet, right? Or a trailer, for example. That's why movies, they promote their movies with trailers. Just a snippet of what's inside the movie before the official release. You do the same with your beats. Show us simply. Post a snippet of it, right? A snippet. Share the snippet, and there you have it. Before the complete work or completed work is officially released. Do you understand? That's a great habit you should start with. But blindly placing your beats and music when there is no paperwork behind it is not a good idea. So be careful out there, because social media can be quite tempting. Many of you would want to create something and just place it on there without even thinking about exclusive and non-exclusive rights. Protect yourself, right? Protect your assets, and you'll do just fine when it comes to placements. Now, let me segue to this, right, about placements. Do you know, if you have a piece of work, whether it's copywritten or not, and it has the opportunity cost, right, or the opportunity to earn money, right? Anytime you have a creation of a piece of music and you submit it on a streaming platform, no matter where you put it, right? It can be your own channel. It could be your own Spotify channel. That is considered a placement. So you don't have to worry about your music being purchased or used by an outside entity for a placement. If you just place your own music into a streaming platform, or you have a business, your own personal business, and you have your own created music within the advertising of your own personal business or endeavor, that right there is considered a placement. So you don't have to worry or wait for some big time movie studio or TV station or even radio or even another artist to be considered placed. You can place your own music on your own platform and make money, and that is considered a quote unquote placement. That's all I have today. And hopefully now, right, there is no question on what a placement, exclusive rights, and non-exclusive rights are. Make sure your music is professionally mixed and mastered with the best quality around. Then once that happens, make sure you submit your paperwork, your copyrights, your trademarks, your patents. Then once everything is approved, then you officially release that particular asset to the public for consumption and for profit. So I hope that helps. Don't be so fast to post your beats without the paperwork. And if you want to post your beats, just post a snippet of that material just to give individuals or fans a hint of what is about to be officially released in the long run or the short run. Take care. Audiolithic Mac here, and I'll be back with another video.